The matter of DP World and Guy involved a restraint of trade dispute. The general manager of DP World at the Port Botany terminal resigned his position. He had a 3-month notice period and a 3-month restraint to not work with a competitor. When he resigned to go and work for a competitor, he was put on garden leave, which in effect means that he was told to he would remain employed, but he was not required to work during the period. He was then advised that after that, he would be, DP World would be fully enforcing the restraint, and he was not to work with a competitor until 27 October 2016, which was another 3 months after the employment end. The employee argued that the garden leave should count as his restraint period as well, that in effect the employment contract ended when he gave notice, and that was the beginning of the restraint. He said otherwise it created a situation where he was in effect having a 6-month restraint rather than a 3-month restraint. It's also relevant that DP World, in enforcing the restraint, said that they were prepared to pay the remuneration he would otherwise have earned from the competitor for the 3-month period after the garden leave, which is quite a significant issue in these type of matters. The court rejected the employee's arguments and upheld the restraint. As a matter of contract, his argument just was not correct, and what occurs is that when you're on garden leave, the contract remains on foot, you continue to be paid in the normal way, you're just not required to do any duties. Contract of employment ends at the end of the garden leave, and then the restraint remains. Due to the access to confidential information that the employee had during his employment, and in fact the reasonably high level of remuneration and position that he held, it was held to be reasonable to restrain him for a 3-month period, and that's what the court did.
So in these cases, it's not unusual for employers to put someone on gardening leave as soon as they give notice when they're quite senior or have a lot of confidential information that could be misused, and it would normally have been the argument that the extra 3 months after the termination date wasn't reasonable to protect the confidential information and the employer's business. But on this case, he actually argued that the termination was effective the date he gave resignation. So it might have been a different case if he'd run it that the additional 3 months, in effect 6 months from the date he stopped providing services to the business, was reasonable.
But I think given his seniority and given the level of remuneration that he was receiving, it probably would have been considered reasonable anyway, particularly it's only 3 months. See, for absolute non-compete, 3 months for a senior person can be reasonable, and particularly if you're prepared to pay the person. It does surprise me to a certain degree that it was run and contested so strongly by the employer, because there was no issue that he was going to lose his position. As I say, 3 months is not a long time. When we're talking, I think he was earning well over 200,000. Yeah. So it surprises me that it was contested, this matter. I've seen issues of total non-competes for 1 year, and you can understand the contest, but 3 months is not huge.
I think one of the lessons for employers here too is that courts, another example of courts really considering garden leave as being a really reasonable exercise. There's never a question. If you're prepared to pay the employee to sit on the sidelines, then courts see that as being reasonable and a very effective way of restraining an employee.
Restraining somebody, and absolutely, and the fact that they were very upfront that they were prepared to pay for the extra period as well. And that in practical terms, it doesn't necessarily fit into the court's consideration, but in practical terms, in my experience, it's a huge factor. When you're in an equitable jurisdiction, if the employer turns up and says, well, I'll pay, this person's not going to be disadvantaged. And we're not talking about a huge period of time. Because apart from anything else, if you as the employer, the former employer, is saying my confidential information means a lot to me, it's going to be catastrophic, the risk of losing it. Well, the obvious answer is, well, you've got to put your money where your mouth is, So I think it was perhaps an unfortunate thing that Mr. Guy in this case challenged this, because he could have just sat back, got the money and not wasted money on legal fees.